So these are some frequently asked questions about the revolving door limit as it applies to the executive branch of government. There's also a revolving door limitation on the legislative branch of state government. First, what is the revolving door? When legislative or executive branch officials leave government service and go to the private sector, it's often referred to as the revolving door between the public and the private sectors. Are elected members of the legislative branch subject to a revolving door limitation? Yes. This limitation is found in Article 4, Section 5E of the California State Constitution. Are executive branch officials of state government also subject to this limitation? Yes. In Article 5, Section 14E of the California Constitution, it provides that the legislature shall enact laws that prohibit a state officer or a secretary of an agency or director of a department appointed by the governor who is not resigned or retired from state service prior to January 7th, 1991, from lobbying for compensation as governed by the Political Reform Act of 1974 before the executive branch of state government for 12 months after leaving office. To whom does the executive branch revolving door prohibition apply? This provision of the state constitution applies to the elected constitutional officers, there are 9 of them, as well as agency secretaries, those are the members of the governor's cabinet, and department directors, who are appointed by the governor and confirmed by the state senate. So first, who's a state officer? Article 5, Section 14F defines a state officer as the governor, lieutenant governor, attorney general, controller, insurance commissioner, secretary of state, superintendent of public instruction, treasurer, and the 4 members of the State Board of Equalization. What statutes have been enacted by the legislature applicable to executive branch officials? There are several statutory provisions that provide further guidance on the revolving door limitation applicable to the executive branch. They're found in Government Code Title 9, Chapter 7, Article 4, which concerns the disqualification of former officers and employees, and it begins with Government Code Section 87406. Is there a name of California's revolving door statute? Yes, it is known as the Milton Marks Post-Government Employment Restrictions Act of 1990. Which section of the Milton Marks Act applies to the 9 elected state officers? That is found in Government Code Section 87406, Subdivision C. For how long is the revolving door limitation applicable to executive branch officials? It applies for 12 months or 1 year after leaving office. And what exactly is the limitation? It says that a state officer cannot be paid to act as an agent or attorney for or otherwise represent any other person by making any formal or informal appearance or by making any oral or written communication before any state administrative agency or any officer or employee thereof if the appearance or communication is for the purpose of influencing administrative action or influencing any action or proceeding involving the issuance, amendment, awarding, or revocation of a permit, license, grant, or contract, or the sale or purchase of goods or property. How is the phrase appearance before a state administrative agency defined? It does not include an appearance in a court of law, before an administrative law judge, or before the Workers' Compensation Appeals Board. Otherwise, it's very broad. Is there a prohibition for state agency employees? Yes. A similar law applies to certain employees of state agencies. This is found in Government Code Section 87406, Subdivision D1. Which employees of state agencies are covered? A designated employee of a state administrative agency, any officer, employee, or consultant of a state agency who holds a position that entails the making or participation in the making of decisions that may foreseeably have a material effect on any financial interest and a member of a state administrative agency. And for how long is this revolving door limitation applicable? It's a period of 12 months or 1 year after leaving office or employment. And what precisely is that limitation? It says that a designated state agency employee cannot be paid to act as an agent or attorney for or otherwise represent any other person by making any formal or informal appearance or by making any oral or written communication before any state administrative agency or officer or employee thereof for which the individual worked or represented during the 12 months before leaving office or employment. The appearance or communication is made for the purpose of influencing administrative legislative action or influencing any action or proceeding involving the amendment, awarding, or revocation of a permit, license, grant, or sale or purchase of goods or property.